I think that one thing that needs to happen is when an objection is made and you are given an opportunity to respond and I make a ruling, even if that ruling is, please clarify, that you then need to obey what my order is instead of continuing to argue. But it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can.
And we are back, and we are back. I want to thank everybody for watching these videos over the past few days. Y'all did not know this, but I was actually stuck on a cruise ship, popped down to Florida, wanted to do a quick 2-day cruise with the wife and the family, just something little, you know, and Hurricane Milton came through, and actually we could not go back to port because the port closed. So we were stuck on the cruise ship for much longer than we expected, but somehow still got these videos out for y'all. So go ahead, give your boy a thumbs up. Come on, y'all. You know, every single day we want to drop content for you, and we were able to do that even though my family and I were stuck on a cruise ship. So not a bad place to be stuck. Anyway, today we're going to get into our final version, our final edition, our final of the mini-series of the Mistrial Madness mini-series. I'm sure there will be more in the future, but we should be all caught up as of now. And if we missed any, you know, shoot me a message. Drop it in the comments. We'll circle back around for the next one and pick up any stragglers. Today, you're going to see Miss Love get harangued by Judge Whitaker. She's going to get half harangued, and then she's going to get a full harangue. Y'all already know, though, Judge Whitaker seems like she wants to see this trial go to the jury for some reason. It almost doesn't seem like it matters what the prosecution does. It looks like Whitaker wants to see this thing go to the jury. But we want to, again, thank everybody for watching. Again, give that thumbs up to your boy. Come on, we out here. We making this content every single day for you. So without further ado, let's go ahead and hop into it. Like, comment, subscribe, and let's go.
You said that you were closest with Moulton, or you were coolest with Moulton. All right. Were you coolest with Moulton in April 2015?
April. Yes.
And were you cooler with Moulton than you were, say, Shannon?
Yes.
All right. Now, in April 2015, were you also cooler with Demekion?
Yes.
April 28th, 2015. Do you remember being with those people?
Yes.
Where?
Then we caught our case. We was in the car together.
What kind of car?
I don't remember what kind of car.
What did you have in the car?
A gun.
How many?
2, 3, 1 on.
And what time did you all get in the car together? Daytime or nighttime?
Night.
Was it after 10 o'clock at night?
Yes.
Right. Had either you or either one of the people you were in the car with been to Club Crucial early?
I think they was.
So how did you end up in the car with them?
Came and got me.
Did you ask them to come and get you?
Yes.
Why did you ask them to come and get you?
Because somebody had shot up my cousin's house.
Where did your cousin live?
On Campbellton.
All right, and who is your cousin?
Alexis Bryant.
All right. Why did you tell them to come get you if you had your own vehicle?
Because my girlfriend was in mine.
Your girlfriend was in yours?
Yes.
All right.
No, I'm wrong. Because I was going to get in the car with my girlfriend. I was getting dropped off to her.
Okay. And so, did you have guns?
Yes.
How many guns total were in the car?
I know I had 2.
And did you see any more?
Demekion had 1.
Were you wearing dreads during that time?
No.
Okay. So, where did they pick you up from?
Cleveland Avenue.
Where on Cleveland?
The store, I think.
Which store?
BP.
Was that the same one you were at with that gun?
Yes.
Before you got arrested in May?
Yes.
Okay. So, do you just normally hang out at the BP for guns?
Yes.
All right. So when they came and got you, what did they do? Your Honor?
Yes.
Hey, I'm trying to figure out who we're talking about.
Your Honor, I, first of all, asked him about people, and then I referred to those people specifically.
All right.
So,
Who are those people?
Your Honor, I'd ask Phil not to continue the question. He'll have no problem.
So is it a vagueness objection?
Yes, it's a Vegas.
Your Honor, I was specific. I asked him about a specific set of people.
I don't know
and
what-
I specifically referred to them.
Yeah, why would
Maybe.
we want to know
I'm
what
s-
we're talking about?
Do you want to re-clarify, please?
I can continue, and then I can ask a separate set of questions. Of course, Mr. Sharp has him on cross.
Well, I think we should be clear about what we're talking about right now.
Ask.
Thank you. Go ahead and clarify.
When I asked you about Garlington, Moncton, and Shannon,
You said Garlington and Moncton.
you didn't hear me say Shannon?
No.
Yes.
That
Let's take
they
a break.
was to
Hang
include.
on. Let's just take our mid-afternoon break right now.
Right.
All right, Mr. Sharp.
Your Honor, what just happened was completely dishonest, disingenuous, misleading, and gross.
And you
I
objected.
objected, and I wouldn't have even thought about anyone doing this other than the fact that I've seen the prior behavior throughout this trial of this type of nonsense where we try to trick a witness into think we're saying they, meaning 3 people, and then try to convince the jury that we're somehow including my client Shannon when it's clear that the witness is not following. That's what we're talking about. Okay. And it's disgusting, and I don't know how we cure it, but I'm going to move for a mistrial. I think it was completely intentional. Obviously, it was calculated. Obviously, when I asked for clarification, I would think anyone seeking the truth would gladly clarify. I'm seeking the truth. I would gladly clarify. No, it's sheepish grin and then.
All right, I understand your objection, and I understand what you were saying past that objection. Miss Love, I think
Honor, may I
one thing that,
respond?
no, you need to listen. I think that one thing that needs to happen is when an objection is made and you are given an opportunity to respond and I make a ruling, even if that ruling is, please clarify, that you then need to obey what my order is instead of continuing to argue.
Your Honor, when I ask for clarification and consideration, I believe that as an advocate and as a person who is actually representing the victims who have been victimized in this case and who is representing as much as actually more than an officer of this court, and I represent something, I believe that the state has as much right to express, to request, and to ask for consideration and for an allowance to ask the questions that it wishes to ask as the defense does. I believe, Your Honor, the objection that was made, and I understand what Mr. Sharp said, but there are a couple of things at play here. One, Mr. Sharp is well aware that Mr. Zachary has said that his client was with him. He has said it in the interview that I'm holding in my hand. He is not being honest with the court when he is claiming that Mr. Zachary had no idea what I was talking about. I literally said Shannon, Demikian, and Moncton, and I asked him how close he was with each of them.
Right. And then we went from that to his girlfriend. And then it was not unreasonable And the objection could just be, vague, but it was not unreasonable to object to make sure that it was clear what the question was, who the they was in the question. And when I say clarify, that needs to be the end of it. And you need to ask a different question, rephrase the question, and let's move on. And there shouldn't be an issue with it.
Yes, Your Honor. If the state is not allowed to ask for clarification or consideration, that I
I don't
understand.
know what you mean by that.
Your Honor, when I
A
ask
clarification of my ruling? Is that what you mean?
when I ask for permission beyond what the court has instructed, I did not know that I should not do that, so I won't do that anymore.
That's not what was going on. You're basically, it seems to say, I'm asking permission to do something other than what the court has just ordered me to do. And so if that's what it is, then no, you cannot do that. If you need clarification of a ruling, then of course you can ask that. And if you want reconsideration, then you can ask for that, but that does not need to go on in front of the jury. When I make a ruling, obey the ruling and move on.
Yes, Your Honor.
Okay.
Your Honor, I really haven't heard any explanation for what happened. I think it was calculated. I'm moving for a mistrial. In the alternative, Your Honor, I do believe that there needs to be a curative instruction, or at least it needs to be clarified who they was. It doesn't matter what he said in the past. He lied in the past. I've already said that. I know what he said in the past.
All right.
But what he's
We don't know. You don't know that he lied. You don't know what the truth is and what the lie is if they are inconsistent. And there may even be a reason for that. Although if they're virtually diametrically opposed, there probably is not an explanation. But when you say he lied, we don't know that.
Okay.
Just like Miss Love doesn't know when he lied.
Well, I'll put it like this. Mr. Stillwell was never charged with those crimes. And Miss Love was not asking about what he said in 2015. She was asking about today.
I understand.
And today, he was clearly responding, they meaning Mr. Garlington, and, well, it's clear to me. I don't believe it's clear to the jury.
Don't talk while he's talking.
And I believe it needs to be clarified immediately because, of course, I will have an opportunity to cross, but I will probably not have an opportunity to cross for about 4 days. And I don't think we should be misleading the jury on direct.
All right, I'm going to look back at what the transcript says.
Thank you.
I mean, and Miss Love, you may, given that there's now a motion for mistrial on the floor, an assertion that you did things purposefully, you may respond to that.
I vehemently object to the mistrial. I vehemently object to any mistrial, and I beg the court to look at the transcript and see what I said right before I asked him the people that I just mentioned. And I would ask that the court, if the court deems it appropriate that such language is gross and all of the disparaging remarks made by counsel for the defendants are appropriate, that's one thing. But I'd ask that the court limit that type of behavior, which is, not becoming of officers of the court.
I agree with that. It is not becoming. All right, y'all can take a break if you want to. I'm going to take a look at this transcript. All right, and in terms, I have reviewed what the line of questioning was, and I do not think that there was anything nefarious and purposeful about trying to trick him into something other than what he'd been talking about. At the same time, I can see how it might have been, well, now, are you sure he knows that the people we were just asking about are the people that you're talking about, him now, coming to pick him up? So a valid objection, it remains sustained, but the motion for mistrial is denied. I am not giving any kind of instruction. You can just fix it by asking the next question. All right, anything else on that?
Your Honor, just for the record. Okay.
Okay, and you use the mic too.
Yep, I understand. Yes, Your Honor, and I understand the court's ruling. I think that all of a sudden the use of they and those people instead of names, and then when asked for clarification, the refusal to do so, I think, suggests that there was some calculation. But I understand the court's finding, but I would ask the court to instruct Ms. Love to clarify with the first question so everyone's on the same page, so there's not confusion amongst the jury, who he is referring to when he's talking about they in the car that night.
Yeah.
Okay, yes.
Your Honor, the state tender states 528 Yankee as evidence.
I would actually object to it if it's not in the facts.
If it's what?
I would actually object to it if it is not as he remembers it to be, if it's been altered, or if it's not the same that he's viewed previously.
Okay, well, it is admitted, subject to the understanding that the date isn't to be relied on because we can't see what the date is.
And I'd also object to any hearsay that may be contained within that document.
I don't know if there, I don't know what the exhibit is. So is that an issue I need to take up?
And ask you, are you able to see the date on the digital version?
I am.
Your Honor, the state tender 528 Yankee and ask for clarification.
Okay, so are you going to, it'll ultimately be, are you just going to make a better copy and substitute? All right, that's fine. Then it's admitted in full.
As we're pulling up 528 Yankee, would you tell the jury what significance you found in 528 Yankee towards your investigation?
Well, there was a phone number posted it was a public post, and there was a phone number that was, there's a comment section to the right of the photograph, and there was a phone number posted by the account holder that appeared to be their own.
Okay. And was the account holder Justin Cobb?
Yes.
What was the significance?
I'm going to object to that as hearsay and ask it to be stricken.
Which part?
Part about who the number belongs to.
Sustained.
Okay. What did you do to determine whose account this was?
Well, I looked at the photos that were posted in the account, I believe. And I mean, traditionally, that's what I would do with an Instagram page. It's just posted in public view.
Okay. And what was it that made the number in this post significant to you?
Well, I was looking for a number for Justin Cobb.
And what led you to believe that this number was a correct number for Justin Cobb?
Well, it was, there's probably more to it than just this, but it was posted in this Instagram comment, and
Was it posted by the owner or user of the account?
That was false speculation. I'd object.
Yeah.
If he has a basis to testify.
Are you able to see and tell, looking at the posting itself, what name the number is next to?
I would renew my objection and also object on the basis of hearsay if he's reading from a document.
It's already in evidence, Your Honor. And,
Okay,
and Your Honor,
when we were up here at the bench.
So, Your Honor, I'll ask additional questions that I think will.
Sustained.
Okay. So, after seeing this
Your Honor,
number,
I have a motion, please. May we step up?
Yeah. I'm going to excuse y'all to the jury room.
Your Honor, so
Your Honor.
well, first of all, my motion is a motion for mistrial based on the actions of the prosecutor. My objection initially to the item was that it contained hearsay. the state represented at the bench that it was not hearsay. There was no hearsay contained in it. We did not address the issue of what the state already knew, which is that there was a phone number attached to it that she was going to try to elicit testimony from this witness about who that phone number belonged to. That in and of itself is speculation, but it's certainly hearsay. The document can't authenticate itself. I believe the site for that proposition is Twiggs versus State. It's 315 Georgia Appeals 191. So this witness can't look at a document and say that it says this phone number is from Justin Cobb's Instagram or social media posting. This is who it belongs to. So that was my objection. I believe the objection was well founded. I believe the state purposely put that up there after misrepresenting as to whether or not it contained any hearsay in it. And based on that, I would move for mistrial.
May I respond?
You may.
Judge,
Can somebody put the document up? I don't see.
yes.
Would you put it up?
First, the state objects to a mistrial. Second, Your Honor, what Mr. Adams indicated that he did not want on here were the comments with where's the phone number? There it is.
Yeah,
Okay.
the comments generally being all of the writing on the right side of the picture.
Your Honor,
And so I said to you, is any of it hearsay? Is any of it being offered for the truth? And you said, no.
Your Honor, what I was asking the witness to do is to tell what was of significance to that number and what he did in terms of finding out and corroborating information that he obtained, because he obtained phone records. I don't intend that this evidence or this exhibit will prove or show that this is Justin Cobb's phone number.
You're asking him that? And
No,
asking
Your
him
Honor,
to testify to that?
I'm asking him, and I understand the court, I'm asking him
you?
what handle it's next to, and Your Honor, what he did after seeing what he saw on this
That's
social
not what
media
you
page.
asked. You represented at the bench that none of this, that being the writing on the right side of the picture, which we're all squinting at because it's tiny on the piece of paper. And so I am relying upon you to actually be honest with the court and opposing counsel so that we can deal appropriately with the evidentiary issue. Was any of it being offered for the truth? And you said no. And then you turned around, and after it was admitted over the overruling of the hearsay objection, based on the representation that nothing was being offered for its truth, you drew the witness's attention to the phone number and tried to have the witness testify to whose phone number it was. If that is not offered for the truth, what is it?
Your Honor, it
What is
explains what steps he next took. It wasn't that he sat there and took this phone number and said, okay, this is Justin Cobb's phone number. He went and sought records based on what he saw on this social media post. So it's not, this post can't prove anything, but I do expect that the witness will testify based on what he saw, regardless, because it's a legitimate.
Why can't you just, at the bench, when you know that the reason you're offering it is for the phone number, and then to ask the witness other questions about what he did based on that phone number and seeing that phone number, say to everybody so that we know what we're dealing with, you know, it's this phone number, and then I'm going to ask him XYZ about the phone number, and then we'll know what we're dealing with.
Because my understanding that what was being objected to was not the phone number, was the comments that was the words, Your Honor. And again, this piece of evidence does not prove anything, as anybody would be able to say. But when he saw this on Justin Cobb's page, or a picture of Justin Cobb next to what he believed to be Justin Cobb's handle, he sought additional information. The entire
phone number with the comments.
I'm sorry, what, Your Honor?
I mean, that is included within what you're now calling comments, all of them just being.
And I asked at the bench what comments they were asserting was hearsay, Your Honor. I literally
And
asked
I
that.
asked at the bench, is any of this being offered for its truth?
And Your Honor, it's being offered to explain DDA Sprinkle's actions that he took next. Your Honor, these records have been collected as part of what he did in this investigation. He was asked on cross-examination, did he take particular steps to corroborate what was given to him in certain interviews? That was the preceding question before I asked him about this particular post. So the state intended and intends to introduce the records that DDA Sprinkle produced or obtained after seeing this post. This post can't suffice to prove that that is Justin Cobb's number. This post only explains why DDA Sprinkle got the number and why it was significant to him in this investigation, where his steps and actions are being questioned.
But you know, Judge, we don't get there. I hear what the state's saying, and it's disingenuous because we don't get to the second step that they're talking about, what records he procured and why he did what he did, unless we go through the hearsay statement that's contained in the portion that I objected to. And the court is accurate. I was there, and I asked for everything that was on the right side, all of the verbiage to be. I said that was hearsay. The state said it was not. It clearly is, because to ask him that specific question, I mean, listen, none of us are obtuse here. It is what it is. I think that the state was disingenuous about it. The state's being very slippery in regards to their response to the court's questions. I think it's willful, and I think a mistrial is appropriate. And I'm asking.
I can't figure out what it is. If it's disingenuous, if it is that, I don't want to malign the prosecutor standing in front of me right now, so I'm not going to say the possible things that it could be, but it is baffling to me that somebody with the number of years of experience that you have, time after time after time, continues to seemingly purposefully hide the ball to the extent you possibly can for as long as you possibly can. And I really don't want to believe that it is purposeful, but honestly, after a certain number of times, you start to wonder how it could be anything but that, unless it is just that you are so unorganized that you are throwing this case together as you try it. And I am sorry to say that, but this case is being made much more difficult for everybody because of the haphazard way in which it is being presented. I'm going to take a recess for a few minutes. I'll have a ruling when I get back. All right, I'm going to deny the motion for mistrial. It's not as if the state couldn't have gotten the testimony in an appropriate way anyway. It's not like the testimony itself is that big of a deal. But I am going to, I'm going to exclude that statement and just tell the jury to disregard the statement and any testimony that had anything to do with the statement. So let's get Mr. Sprinkle back. Did you want to put anything on the record, or are you just getting ready for the jury?
I'd like to put just a matter before the record for the court.
All right.
Your Honor, this is from United States versus Roberts, Roberts. It's 640F 2nd 255. It's the 9th Circuit, 1981. It's been cited many times. It specifically says that continued prosecutorial misconduct may show a course of conduct establishing the intent to provoke a mistrial and bring into play double jeopardy considerations. You have not been here the whole time, and we thank you for being here. But starting with opening statement, and I know you got my motion.
I know, and I know what your argument is. Here's the thing is that, and I understand what that law says as well. Ms. Love does not appear to be trying to get a mistrial so that she can try this case over again, which I know if that were what she was doing, she wouldn't be able to try the case over again anyway. So that's just not applicable here. Now, is there continued prosecutorial misconduct merits a mistrial anyway, based on that? Yes, potentially we get to that point at some point. But there is not, from what the court's vantage point is, an indication that the state is trying to goad anybody into moving for a mistrial so that they can retry the case because they think they're losing the case. I think they think they're winning the case.
I don't know. I don't know what they think, but I will say this. This is not becoming in the state of Georgia of a trial. And it is all the time. It's all the time. At some point, it's got to end. Because this is not fair to Mr. Williams, and I assume the other people on trial will agree. It is this constant hiding laws, citing law that does not stand for what it stands for, not giving over information, not answering the court, arguing with the court, and I think that it does rise to a level now, but I understand what you rule, but I think that we're well beyond it. And the reason I said promote these things is it's literally.
Oh, I saw that. I know. I mean, I think my frustration was apparent a few minutes ago. But I truly am struggling with whether all of this is purposeful or this is just really poor lawyering on the part of members of the state's team. Either way, it's really unfortunate. If it's something other than poor lawyering, then it is more than unfortunate. But at this point, and we're going to just move on with that exhibit being excluded. I don't know if I can stress any more than I already have how much the state's lawyers need to make an effort to be upfront and forthright in the trial of this case. So let's get the witness back in.
Your Honor, would you allow me to either renew my motion for mistrial or consider that my motion is renewed before the asking of the next question, please?
It's renewed.
Thank you.
Sergeant Gaither. Do you recall during the time that you and Detective Dennis spoke with Quindarius Zachary, talking to him about the day Lucci's mother's house was shot, or one of the shootings at Lucci's mother's house?
Yes.
Before you spoke with Quindarius Zachary on August the 5th, 2015, did you have information, any other information that Shannon had a 223 on that day before you spoke to Mr. Zachary?
No.
And before that, did you have any information about the type of gun Woody had at the time Miss Reed's house was shot up?
No.
And before you spoke to Mr. Zachary, did you have any other information about Pokey being involved in Lucci's mother's shooting?
No.
Throughout the interview with Mr. Zachary, did he provide you with what you would have considered incriminating information about Kenneth Copeland
that you had not previously received from other sources?
Yes.
And what about Mr. Garlington? Did he give you information about Mr. Garlington that you had not received from other sources?
Yes.
Did he provide you with information regarding the January 10th, 2015 murder of Donovan Thomas and what happened before and after that you had not received from other sources?
Yes.
With respect to Antonio Sledge, did Mr. Zachary, during your August 5th, 2015 interview with Mr. Zachary, give you what you would have considered incriminating information about Antonio Sledge?
Yes.
Was that information known to you from any other source before you talked to Mr. Zachary on August the 5th?
Yes. Some of it, yes.
Was all of it?
Not all of it, no.
The information regarding Mr. Sledge shooting at Kel with Woody, was that known to you?
No.
And would you consider that incriminating information about Mr. Sledge?
Yes.
Did Mr. Sledge ever hint to you at any time during his interview with you that he had anything to do with shooting at a rival gang member?
No.
Did the information that Mr. Zachary gave you about Tay being a person that you knew to be affiliated with MDC, did I get that right or did I get
Yes.
that wrong? Did that cause you in any way to question or challenge what information you were being given by Mr. Zachary?
No.
Why not when MDC is a different group from YSL?
He provided information that some of it which I already knew would.
Your Honor, the assertion regarding it's not bolstering. It is an effort to show.
I'm going to sustain and you can rephrase.
Okay. Why did Mr. Zachary's explanation regarding being from Capitol Homes, him being from Capitol Homes, Mooktoon being from Capitol Homes, and Tay being from Capitol Homes have any significance to you?
Sustained. She said, or he said, assumes facts not in evidence.
During the interview, do you recall Mr. Zachary talking about himself being from Capitol Homes, Mooktoon being from Capitol Homes, and a third person that belongs to another group being from Capitol Homes?
Yes.
What was that third person?
Tay.
So during the interview, did Mr. Zachary talk to you about him, Mooktoon, and Tay all being from Capitol Homes?
He did.
Did that information have any significance to you?
It did.
What significance?
I showed a prior relationship
Between
those three individuals.
Okay. Despite the fact that Tay was MDC and Mr. Zachary and Mr. Sledge were YSL?
Yes.
Sustained.
I'll withdraw it. Thank you. I'll withdraw. Why was the fact that those three people had a prior association of any interest in your investigation?
It showed their continued alliance, even though they were from different gangs and lived on different sides of town. Presently, it showed their prior relationship from their roots, which was Capitol Homes.
Did that information in any way help you confirm, corroborate, or disprove the information you were getting from Mr. Zachary?
It made me believe it more. Corroborated.
Sustained.
So not talking about what you believed.
Okay.
Hang on just a second.
Move to strike.
That'll be stricken. Please disregard that last answer.
Did that information corroborate or disprove for you any of the other information that you got from, and Your Honor, my understanding is her belief is irrelevant, but corroboration towards her, what she considered corroboration is relevant and important. Because,
I hear an
okay,
objection. Yeah.
so
Yes.
did it, okay, thank you. That's 151, please. Showing you 526 Yankee Juliet. Or publishing for the jury. Is that location the one that you described as 151 Cleveland, the BP gas station?
Yes.
All right. Thank you. Now, did you go down to any rental agencies yourself to try and locate any rental vehicles that Mr. Zachary talked about Defendant Williams having during the time of Donovan Thomas's murder?
For
You
that,
yourself.
not for the murder, no.
Was that something that Detective Thorpe was primarily responsible for, or was that?
Yes, that was his case. He was a primary.
Justin Cobb, before you heard the name Doo-Wop from Quindarius Zachary, did you know Justin Cobb to be affiliated with any gangs?
No.
And did you ever classify or get information that caused you to believe that he was or wasn't?
Confrontation clause.
Overruled.
I don't recall. I don't believe so.
Okay. Was Quindarius Zachary the first person that you learned of the name Justin Cobb from?
Yes.
Now, when you were talking about Doo-Wop and you said, I think either you or Mr. Zachary talked about him being on Yak's IG.
Mm-hmm.
Do you remember saying one of the people in the room motioning, or Mr. Zachary actually motioning about height?
Yes.
And at that time, had you already seen Justin Cobb on Diamante Kendrick's IG?
Yes.
So if he was not someone that you had known of before your interview with Quindarius Zachary, what was the circumstance that you would have seen him on Diamante Kendrick's IG?
He was like a rapper and had some song out. Like, I don't remember exactly how the words go. It was a little catchy little song that I saw on Mr. Kendrick's Instagram page that tagged him in it. But I didn't know the significance of, him necessarily being involved with YSL at the time that I saw it.
And is Justin Cobb someone who is significantly short or significantly tall or just average height?
He a little thing. He's small. He's small. Short, rather.
Before talking with Mr. Zachary, did you have information from any other source that Nard was concerned that Woody might fold and tell that Nard, Shannon Yak, and Duop had killed Donovan Thomas? Information from any other source?
Objection, Your Honor. Confrontation clause.
Sustained.
Your Honor, when you heard from Mr. Zachary that Nard was worried Woody would fold, that he, and tell police that Nard, Yak, Shannon, and Duop had murdered Nut, was that the first time that you had heard that?
Yes.
What?
Yes.
And when you heard from Mr. Zachary that Thug asked the members of YSL responsible for killing Nut, why'd y'all kill Nut? Okay, let me play for you. Do you recall during your interview with Quindaria Zachary when Detective Dennis asked what was Thug's mood like when you all were in Miami?
Yes.
And do you recall or whether that was immediately following the Donovan Thomas murder?
Yes.
And do you recall whether Mr. Zachary said Thug was calm?
He was normal.
Or normal? Thank you.
He was normal.
All right. And do you recall whether Detective Dennis asked, he didn't care, he didn't give a fuck? Do you recall that?
Yes.
And did Detective Dennis ask that question?
Yes.
And did Quindaria Zachary follow that up with sort of an explanation?
He did.
Would you tell the jury what that explanation was for why he said Thug was normal?
He stated because Nut gave the whoop or the green light for members of YSL, so he was just like, whatever, after that.
And when you say Nut gave the green light, when he talked to you about Nut giving the green light, did he also tell you or state that Thug asked, why did y'all kill Nut?
Yes, he did.
And was that the response Mr. Zachary told you was given to Defendant Williams while they were in Miami?
Yes.
And did Mr. Zachary tell you that Thug seemed then satisfied with why they killed Nut?
Sustained.
Without talking about exactly what was said, do you remember that conversation being discussed with Mr. Zachary?
Yes.
All right. When Detective Thorpe came into the room, did you already know that, or his former, or if whether he had a relationship with Mr. Zachary in any other capacity?
No, I knew that Investigator Thorpe had worked at Crawford Long Middle School for years, but I didn't know that they actually knew each other.
Okay. And during the course of your interview with Mr. Zachary, did you understand Mr. Zachary to correct you at any time during the interview if something was inaccurately stated?
Yes.
Other than changing his account of his whereabouts on April 28, 2015, as it related to the Adele Drive shooting, did Mr. Zachary give you changing accounts of anything else during the course of your interview?
No, he was pretty consistent with the information that he did provide.
What about as it related to the guns that he had and which ones he had and which person had that gun at what time?
Yeah.
Did that remain consistent over the course of the interview, or did you perceive it to have changed significantly at times?
No, it stayed pretty much the same.
And were you all able to sort of keep up with who had which gun?
It was sometimes confusing, and I would write different things down or say different statements that were what I perceived as what he was saying, and he would correct me and say, no, this person had this or this person did that several times throughout the interview.
After you talked to Mr. Zachary on August the 5th of 2015, did you do what you had said to him that you would do and tell someone within the district attorney's office the information that you got?
I did.
Now, did you have anything to do with any charges federally that were brought against Mr. Zachary? Did you take out any federal warrants?
No, I didn't.
The proffer that, are you aware of whether Mr. Zachary sat down in a room with investigators 2 years after he spoke with you and Detective Dennis and Detective Thorpe on August 5th, 2015?
Am I aware of it? Or was I there? I'm sorry.
Do you know about a 2017 interview with Mr. Zachary?
I heard about it, but
Were you there?
no.
Okay. And between August 5th, 2015 and 2017, during the time you understood that other interview to have taken place, do you know whether or not Mr. Zachary was housed with anybody that he had talked about during the interview?
No, I'm not aware.
Okay. You don't know one way or the other?
I don't know.
Okay. Were you on scene at the compound the night that Lil Wayne's bus was shot up?
No.
During the interview with Mr. Zachary on August 5th, 2015, do you recall sort of deferring to Detective Dennis at some times?
I did.
Did you all discuss the Lil Wayne bus shooting and Quindarius Zachary's presence at the compound during that interview?
Yes, we did.
Is that one of the times you deferred to Detective Dennis?
It is.
Why did you defer to Detective Dennis?
He was on scene the night of the Lil Wayne bus shooting at Club Compound. And it was just kind of one of those things. He had more of an interest than I did. Again, he was on scene. He had firsthand knowledge of what happened and the persons involved. So I just kind of deferred the case to him for him to handle along with Cobb County PD.
And this is despite, even when you went in to talk about Adele Avenue, you deferred part of it to Detective Dennis for that reason?
Yes, I knew about it, but as far as, intricate details and everyone that was on scene, it was too much for my brain at the minute, so I just gave it to Dennis.
Do you remember how many cars Quindarius Zachary said that he and the group he was with were in the night of the Lil Wayne bus shooting?
Yes.
How many?
I believe he said 10.
Before he said that, did you, not speaking about anyone else, but did you have knowledge or information about a number of cars they were in?
Yes.
From who?
I saw the video
Okay.
from the studio.
And when you talk about the video from the studio, what studio are you talking about?
Vault Studios, located at 675 Metropolitan Avenue.
How did you come to be looking at video from the vault on any particular time?
Investigator Dennis and I went to Vault Studios and retrieved the video surveillance. Well, recorded it and had, I believe, Investigator Teague retrieve the actual video. But we saw a group of vehicles leaving Vault Studios shortly before the Lil Wayne bus shooting.
I can't hear you. I'm sorry.
Me?
I'm going to object best evidence rule if there's a video.
Okay, overruled.
Go ahead.
I saw the video that we obtained, and it showed a group of vehicles leaving the studio before the shooting and arriving back to the studio after the shooting.
Okay. Did you, before you talked to Mr. Zachary, did you in any way alert Mr. Zachary by any member of his family or any other way to the approximate number of vehicles that you saw in that video?
No.
Outside of the investigation that was conducted by Detective Dennis in that Little Wayne bus shooting, did you have independent information that about the details Mr. Zachary gave you during that August 5th interview around this Little Wayne bus shooting?
No.
Do you know whether Detective Dennis had information during his investigation that could corroborate or disprove parts of what was being said?
I'm not sure.
Have you ever had interviews where you're sort of forced to decide or determine whether somebody is trying to put blame here to get blame from somewhere else during your time as an investigator with the gang unit?
Sustained.
Okay. During your interview with Quindarius Zachary, did he give you any indication that his reason for talking to you was to get Shannon in trouble and get Demikian or Woody or Moontum out of trouble?
Objection, Your Honor. Bolstering
Speculation.
and speculation. Thank you.
Yeah.
Overruled is to speculation. Overruled is to bolstered.
You may answer that question. Do I need to ask it again?
No, I think I understand it. No, it didn't appear that he just wanted to get them in trouble. I took it as he wanted to try to help himself as much as he can by providing truthful information.
Speculation.
Overruled. Well, sustained is to speculation.
Okay.
I also have a motion, Your Honor.
You have a
Motion.
all right. Time for our morning break anyway.
Your Honor, at this time, I'm going to move for a mistrial on behalf of Mr. Stillwell. We have, first of all, I'll point out that we've been referring to Ms. Gaither as, I believe, Sergeant. And I say that to say that she is not someone that just came off the street to testify with no understanding of how the process works. She's experienced. She's, I'm sure, testified many times before. She just informed the jurors that her belief is that Mr. Zachary did not want to harm Mr. Stillwell specifically, but that's not my objection. My objection is she testified his intent was to come in and give truthful, to get himself out of trouble by giving truthful information. That was absolutely improper. That was vouching for a witness. That was bolstering. And that is a basis for a mistrial. From an expert, I'll point out as well.
Your Honor, my response is that the court very well could and should instruct the jury that as to the witness's opinion about a interviewee's, well, first my response is we vehemently object to a mistrial. Secondly, the court could and should instruct the jury that a witness's opinion about another witness's statements or, testimony or anything that they said is not to be considered by the jury. The jury is the person that determines the credibility of the witnesses. And I can make certain that Sergeant Gaither knows when I'm asking regarding any indication that to not talk about truthfulness, but just to give objectively what indication or whether she considered that there was an indication. Secondly, a mistrial is in no way warranted in this case when Sergeant Gaither did not say Quindaria Zachary was being truthful. She said, I perceived, and that is why an instruction would be warranted that her opinion about his truthfulness is not to be considered by the jury. They make the determination about credibility. There is nothing about any of the exchange that just occurred that warrants or in any way justifies a mistrial. At best, an instruction is called for.
That I initially objected to the question to begin with, and I saw the danger, and the state insisted on asking that question that prompted this response. That was completely inappropriate.
All right, thank you. I'm going to instruct the witness as well. So we'll go ahead and take a break. And when we get back, I'm going to have the witness in and instruct her and then give an instruction to the jury.